we're ready. Should we get going? So, hi there. Thank you everyone who could make it online for Piotr's presentation. So I'm just going to quickly introduce him and then we'll get on the presentation and hopefully have some time for questions and discussion after. So Piotr Szwedo is an associate professor in the Department of Public and International Law at the University of Jagiellonian in Kraków, Poland. He's also the head of the Coordination Centre for Foreign Law Schools and the Centre for Advanced Sustainability Studies. He graduated from the School of French Law at Jagiellonian University in France. Since then, he's also studied at the Faculty of Law and Administration at Jagiellonian University and the Catholic University of America. His scientific interests focus on international economic law, sustainability development law, and water law, which is what the talk today is going to be about. He's written and contributed to numerous books on these topics, along with publishing multiple articles. So today he's going to talk about the legal personality of rivers, which I'm looking forward to hearing more about. So over to you, Piotr. Thank you.
Thank you. Thank you very much, Sarah, for this brief introduction. And thank you everyone for coming and sharing this moment for reflection on legal personality of rivers. Myself, I'm an international public lawyer, mostly working on international economic law. So the field I come from is more interested in economic interrelations between states, trade relations. So my PhD was about how to liberalize trade, mostly how to increase trade volumes. Also, I was teaching international investment law. It's another branch, another sub-part of international economic law, something that is contributing in flow of capital, investing from one country to the other. And the international investment law is answering the question, what happens if a given economic operator invests from country A to country B and something bad happens. By bad, I mean, for example, expropriation or discrimination, and then this economic operator, this company has to leave. And very often this is what we call expropriation. And international investment law is dealing with that. So if you hear this message, probably you can imagine this is not something that is closely related to legal personality of rivers. So how I became interested in this particular question, right, or this particular problem? Well, when in the middle of pandemic, I was reading different investment cases, and one of the cases was against Ecuador. In Ecuador and also in South America, you have different investment cases which are related to natural resources. I mean, this is the region when, to my understanding, you have maybe the most dramatic sustainability dilemmas. Because on the one hand, in those countries, like in Ecuador, you have a beautiful nature, you have richness of nature and of natural resources, and you have also a big dream and tendency to boost economic growth. Right, and so those tensions between economic growth and environmental concerns are of particular importance over there. And one of the cases I was reading, Burlington versus Ecuador, was about a situation when there was an economic operator coming from Europe who was working in the petroleum sector. In the Amazon, they were extracting oil, and there was a spill of oil, which polluted the forest, right? And Ecuador decided to react because of it and decided to cancel and close down this company's economic activity and kick out the company out of Ecuador. And investment law is about consequences of such actions. So this company sued Ecuador on the ground of international investment law. And it was making claims, because we lost our company, because we lost our income, we would like to have compensation. And the interesting story behind was that Ecuador was making a very interesting argument against those claims. They were saying that in Ecuador, we have a very special legal system. We have a new constitution. And this new constitution has a very particular chapter. This chapter is about rights of nature. The rights of nature, which are referring to the idea that nature, its elements are not only objects of protection, but are also subjects of rights. And this very interesting concept, very appealing to imagination, was there in this very particular investment case. There was maybe a half of a page about this. And it inspired me to pursue my research related to this question, right? How it is possible that parts of the ecosystem, some elements of nature may have in legal system legal subjectivity, and what does it mean actually in practice? What are the practical consequences of this standpoint? And yes, and we decided to continue with my little team this research. We received a research grant, and this I will present now. So the legal personality of rivers is first and foremost inspired by this research we're conducting here. We have a website called Ronsus. I will maybe type it into the chat box. Voila. So if you want to take a closer look to our research outputs, they are there. This is a research question or research project, which is trying to answer the question whether legal personality of nature may foster sustainability, and to what extent, and what does it mean, okay? And today I will talk mostly about legal personality of rivers, because in this lecture series, we are mostly focusing on water. I also, in my academic career, I was also focusing on economic and legal aspects of water. I was researching about the status of water in international law. In the economic context, I was asking myself a question if water is more a product or more an object of trade, or it's rather a right or a heritage. It's another project that I was conducting. So things I will say today is a combination of those two intellectual trajectories which met one day under the umbrella of this presentation. All right, it was a kind of short introduction, and I will maybe now share my presentation and continue with the presentation. All right, so this is where we are. Before we embark on legal personality of rivers, let's, as I understand, you are not necessarily students of law or lawyers yourselves. Let me briefly explain what term legal personality means. Well, we as lawyers, we differ from the rest of society because we have very deep faith in different things. We have a very special deep faith in law, in the sense that if the law says something, we say it really exists, right? Legal personality is a fiction that lawyers believe, but also the rest of society believe that something exists because the law says so. Well, if, for example, the law says that a foundation or an association or a company exists and it's an independent subject, we believe as a society, and we as lawyers, we also believe it's a different entity, right? And it has practical consequences for our behavior also. So if I go to my rector's office and I talk to him and I shake hands with him, it also means that I'm not only talking with him as a physical person, it means that he represents the whole university for me, right? Because he's leading this entity, he represents this particular subject of law. Same applies to other subjects, to companies, to churches, to associations, to foundations. And we have a lot of different kinds of different subjects, legal subjects in different legal systems. Of course, it's a fiction. Such subjects exist in a slightly different sense than other categories of subject like physical persons. But we all experience the practical consequences of it, right? Not only in terms of law, but also in terms of, social and economic interactions. Of course, you could ask a question why legal persons were created, why we as society came up with this idea of creating legal persons, and I'd say the functional explanation would be that it's easier or more pragmatic to achieve different goals. They can be economic goals, they can be non-economic goals through legal persons, right? So it's much easier to operate a business activity through a company. It's easier to teach when you have a distant legal subject at university or school, right? It's easier to organize a religion if you have a church, etc., etc. That's why such subjects exist under different labels, under different names, in different legal fields, right? On the other hand, we also experience in the evolution of legal system, evolution of human rights, right? And human rights, they did not necessarily always existed. I would say that modern human rights is a concept of the French Revolution, historically speaking. If you follow the history of Europe, for sure one of the very important historical events was the Great French Revolution, which actually ended the feudal era, right? Before that, we lived in societies which were divided into different economic and social groups, and starting from the Great French Revolution, it equalized citizens into citizens, right? And the great declaration of citizens after the French Revolution actually gave rights to all people, independently how they were born or where they were born, in what social group, right? And then this human rights concept evolved and integrated different subgroups like women, children, different marginalized minorities, etc., etc. And the consequence of this process, some say, is the integration also of animals. That's why we are talking about animal rights, and also of ecosystems. And this is why we are talking about rights of nature. So those are the two trends I would like to mention as a starting point. Creation of legal entities as legal fictions, but having pragmatic and evidence consequences in our societies, and also evolution of human rights, embracing different categories of subjects. Then those who claim establishment of legal personality of rivers or of nature say we need this because in order to protect nature in a more effective way, they have to have standing in front of courts. They have to have legal standing in front of courts, in front of tribunals. This is also triggered to one more factor that I would like to mention, is an overwhelming criticism of environmental law. Some people say that environmental law exists, but it's completely non-effective. It's not protecting nature in a sufficient and effective way. And for that reason, we need new tools, we need new concepts, and rights of nature is one of those possible ideas. And some countries picked up this idea and implemented it to its legal systems. When I say some countries, I mostly think about two very important examples. One would be Ecuador, and you will hear about Ecuador a couple of times today, probably. Ecuador, which I have just said, has a chapter of the Constitution about rights of nature, derechos de la naturaleza, but also New Zealand, right? In New Zealand, they introduced this idea of rights of nature and rights of rivers. Particularly when I say rights of rivers, I mostly think about Wanganui River, which is on New Zealand's Northern Island. It's one of the most famous examples of such categories of legal subjects. When I also talk about rights of nature and its let's say axiological or philosophical underpinnings, I must also emphasize the need to underline the term intrinsic value of nature. Very often, environmental law was criticized because and was accused because the claim was that environmental law is protecting nature only for the sake of humankind, only because it wants to at the same time protect interests of people, of humans. Rights of nature is shifting this paradigm from anthropocentric to ecocentric. Anthropos, as you probably know from Greek, it's a human, right? And one of the concerns, one of the challenges is at least from the perspective of rights of nature proponents or propagators, is that this system as it stands now is too much anthropocentric. We should seek and try to develop, try to conceptualize a legal system which is not anthropocentric, which is ecocentric, which balances rights and balances values in a more coherent way, in a sense that it takes into account also this intrinsic value of nature. So value of nature per se, not for a human being, because if we just instrumentalize nature in that way, we'll never reach a correct balance between those interests and a correct balance between different elements of the ecosystems. Then, on the top of that, we also have to mention that rights of nature, they mostly appear as a legal concept as a result or as a consequence of colonial past, and it appears mostly in post-colonial countries. Ecuador and New Zealand are already examples of that categories of states, but also rights of nature are being discussed or appeared in countries like Colombia, United States of America, Australia, Canada, India. In Europe, I would say the most active discussion is taking place in Spain, but also France. Recently, quite also in Poland, but even if Poland, I wouldn't call it a colonial or post-colonial countries. But those countries which I have mentioned, they are mostly sharing this colonial or post-colonial discussion, right? When we say colonialism and post-colonialism, a problem or a category of subjects which appears are the indigenous communities. Indigenous communities are those communities which existed in given countries before Europeans came, so before the process of colonialism started. The process of building or reconstructing the legal system towards rights of nature is at the same time a process of reinventing the roots of those societies and legal systems as they appear before Europeans came, right? And very often those legal systems were pre-Christian, pre-Western system which had some kind of reference to nature, which had some kind of reference, for example, to Pachamama as Mother Nature, like it appears in Andean part of South America, right? Also, those societies used to live in a much closer relationship to nature. Very often, they had a kind of personalized attachment to it. They treated nature as subjects, and it has a consequence on how rights of nature are being conceptualized nowadays when we go back to those images, when we go back to those ideas which existed before Europeans came. Also, rights of nature can be an advocacy or an element towards what we call TWAIL. Especially in international law, we have a term which is called TWAIL. It's an abbreviation, it's an acronym of Third World Approaches to International Law. Probably you know the term Third World. You have the First World, the Second World, and the Third World. Third World Approaches to International Law, it's an idea of rejecting the domination of the First World, not only in economic discourse, but also in legal discourse. Those who advocate for TWAIL, they say that international law was mostly constructed and built by Western countries, which dominated the political scene in 19th and 20th century. And still now, even if the decolonialization process is in theory at least over, we also have to decolonialize law as such, international law as such. And rights of nature, which is also being advocated by United Nations under the umbrella of Harmony in Nature program. Rights of nature could be interpreted as part of this TWAIL movement. Next slide. Yeah. Yeah. So when we reflect on this idea, when we think if rights of nature could become part of TWAIL and could become part of general and universal international law, we have to reflect on another problem, which is the problem of what we call legal transplants. Well, legal transplants are ideas or concepts analyzed by someone or by specialists of comparative law. You know, lawyers, they have a kind of sub-branch which is called comparative law. So these are mostly specialists in different legal systems, and they do some kind of comparison. We try to do from time to time such exercise here in our Center for Foreign Law Schools. Here in Krakow, we gather together with specialists from different legal fields coming from different countries, and we try to compare how different things are being regulated in those countries, and we ask ourselves a question: which regulation is better? Could it be transplanted from country A to country B? By transplantation, we mean borrowing it or copying it from the legal system A of country A to legal system of country B. And what comparatives they do, they also study why sometimes those legal transplantations fail, right? And very often they fail, but not necessarily for, I would say, purely legal reasons, but for non-legal reasons. So reasons which are not necessarily resulting out of differences in legal regulations, they are rather resulting out from political, cultural, economic, mental differences between different groups or different parts of societies, right? That's why, for example, sometimes legal transplantations of German law, for example, failed in China because society is completely different. Also, some Soviet regulations failed in my part of Europe. They were not implemented, or even if they existed on paper, they were not working, and they were not put from letter in law to law in action, right? very often you have some religious or local customs which have an impact on human behavior. Because as probably you know, and it's absolutely true, that not only law governs our behavior, but there was a number of different set of rules like ethical norms, moral norms, religious norms, cultural norms, which have a huge impact on what we do and how we do it, right? And law, if it's not in correlation with all those categories of norms, very often they are not effective, right? So you have a number of reasons which you have to take into account when you start to reflect if rights of nature, which work in some societies like Ecuador, like New Zealand, like Colombia, would it be efficient? Would it work if we try to copy paste them from those countries to other parts of the world, like continental Europe, for example? And in our research, we already mapped certain categories of risk, and one of those risks are of, I would say, philosophical or ethical differences, right? Well, uh, you can be critical about this, but law as such, especially in its, I would say, continental European edition, is anthropocentric. And it's not only because of our religious beliefs, but it also comes from our secular heritage. Well, in Christianity, but I would say also in all Abrahamic religions, so all three Abrahamic religions, which is not only Christianity, but also Judaism and Islam, the idea of certain exclusiveness or the idea of certain uniqueness of a human being vis-a-vis other categories of beings is pretty much clear. If you read the book of Genesis, right from the first letters, first verses of the book of Genesis, you clearly see that human being is distinct, is different from other categories of beings. But also, when you take into account the secular heritage of Europe, you very clearly understand, and this is something that we talked about when we talked about the French Revolution. Well, the French Revolution is based on the idea of human rights, and the whole idea of human rights is based on the idea of human dignity, right? So human dignity makes human beings different, makes human beings unique. And because they are unique, because they are different, they have rights, okay? And the whole discussion it's already kind of philosophical discussion if other categories of beings, animals or ecosystems or plants or rivers could have also some kind of dignity and therefore could have rights. And here you can reach all different kinds of answers. And probably you would have a different answer to this question in Latin America, different answer in sub-Saharan Africa, and different answer in Western Europe, right? Well, but it's when you reflect on this, you clearly see it's not necessarily such an easy exercise just to copy paste rights of nature from country A to country B, and it not necessarily means that it will work or it will bring any kind of effect. Also, what we have to take into account, what may create some kind of social reluctance towards rights of nature, is the economic price, some say, right? Well, when you have something what we call inflation of rights, so you have too many rights, you clearly reach a conclusion that those rights bring some rights to some categories of subjects, but also if you have too many rights, it limits some freedoms of other categories of subjects. So for sure, declaring rights of nature would limit possibly some human rights, like the human freedom of economic activity, which is being present in all categories of constitutions and also international instruments. So when you trigger this discussion, you clearly see that it's not a 0-1 answer, but also a positive answer to rights of nature comes, or may come at least, with some difficulties and for sure with some price that has to be paid. Then why rights of nature are often linked to rivers? And there's a number of reasons why very often when we talk about rights of nature, we take into account examples of rivers indeed. Well, first, and you have a number on the slide, you have a number of important examples. So Wanganui is one of the mentioned, but also Atrato River in Colombia, Vilcabamba River in Ecuador, Ganges and Yamuna River in India, Magpie River in Canada, etc. Well, first, rivers compose some kind of distinctive ecosystem. So usually you know where the river starts and where it ends. It creates some kind of distinctive ecosystem when you have the basin of the river. And alongside this river, you have a significant independence of river health and human settlements. You have very often cities which are on the banks, economic activity which is depending on the health of the river, etc., etc. So that's why very often you have an important interrelation between the quality of the river and the quality of the ecosystem and the well-being of human beings, right? Also, very often there's a discussion or very often you have distinct interest of, for example, of populations who are living on the upstream part of the river and downstream part of the river. Especially it's clearly visible in international law. And you also have conflicts of different categories of uses of the river, right? Rivers usually in the past, they served for two categories of economic activity, let it be fishery and transportation, right? Now it's very often something different. We also add to it energy production, for example. So when you start regulating those different categories of uses, you have to take into account how it will impact other categories of uses and what will be the consequences for human beings, right? So that's why rights of nature proponents or propagators, they say we have to take a look at the river as we have to imagine it's a person, right? And take a look at this as a person which has to have a kind of holistic well-being guaranteed by the law, right? That's why we very often take into account the examples of rivers. Then you have a number of cases here. I will not talk about them into details because it will be too time consuming. I just wanted to briefly mention. So we had the 9 cases which I produced, but there are even more than that. So we have a Vilcabamba River from Ecuador, which is a very scenic Andean water course. And a local road widening project near the river banks led to a dumping of large amounts of the construction debris into the waters. And the 2011 judicial decision invoked Ecuador's constitutional provision guaranteeing the rights and granting rights of nature, and the court had to decide what are the legal consequences of this legal personality, and it argued and mandated the remediation measures which allowed to remediate measures which were overly burdensome and not just justified under the rights of nature framework. Then in Colombia, there was a problem with mining activities and mercury contamination and deforestation. And also the legal personality of the Atrato River was a consequence of the Colombia's constitutional court decision. So also this legal personality has roots in different legal sources, like we lawyers say. Sometimes it's the constitution, like in case of Ecuador, but sometimes it's rather a result of the activity of courts, like in Colombia. In Canada, there was a Magpie River. Again, There was a tension with the hydroelectric development of other source extraction activities, and different municipalities in 2021, they declared rights of this river. So here in this particular situation, the legal personality of the river is resulting out of a declaration of local communities in this case. Then you have Yamuna River in India. It's again resulting out of a court decision, High Court of Uttarakhand, which recognized Yamuna and Ganges rivers as legal entities with legal personalities. And in New Zealand, this is the example I mentioned. It's the legal personality of Wanganui River is a pure consequence of the decolonialization process in New Zealand. In 2017, the parliament has passed the Te Awa Tupua Act, in other words, Wanganui River Claims Settlement Act, which recognized Wanganui River as a legal entity. Well, it was also, if you take a look into the behind of the scenes of this process, in New Zealand, there's a constant process of decolonialization, which is, on the one hand, you have the tribes, the Maori tribes. On the other hand, you have the crown, so the New Zealand state. And very often they are looking for some kind of compromise on how to govern different lands, which before were owned by the Maori people, and later on they were colonized by the crown. So the interesting political process which took place in case of Wanganui River was that the declaration of the legal personality was not only a consequence of, or not only the idea of achieving environmental protection, but also to find some kind of compromise on the legal status of the river. And the idea is that the river owns itself. It's not owned by the crown. It's not owned by the Maori people. It owns itself, but it has a board in which different interests are being represented, including, of course, the interests of the river itself. Then you have a Turak River in Bangladesh. Again, a huge pollution, and in 2019, the Bangladesh High Court declared the Turak River to be a legal person. Then you have Mar Menor. Mar Menor is not a river, it's a lagoon, but it's the most famous European example of a legal person. By the way, it was a consequence of a university activity. So over there was in Murcia, the University of Murcia, there was a group of active students, and together with a professor of philosophy of law, they decided to lobby for a declaration of the Mar Menor as a legal person, and it passed the law. And now we're just trying to figure out what are the consequences of it, because it's quite recent, so just 2 years passed. And it turns out that farmers are not necessarily very happy about having Mar Menor as a legal person, because, of course, it's something that we mentioned before. It limits considerably the economic activity and farming processes at the lagoon. In France, you have the example of La Loire. La Loire is the most famous and the biggest French river, and it's still not the law. It's at the stage of the legislative proposal, which is quite recent. But before that, they had something that was called Le Parlement de la Loire, so the Parliament of the River Loire, which was a kind of community forum where they discussed different interests of the river itself, and also of all those subjects living on the bench, at the bench of the river. And also in Poland, in my home country, I have a discussion around Odra River, or Oder River, which is a river, a border river between Poland and Germany. In 2022, there was a terrible pollution of this river in summertime, and because of lack of high temperatures and lack of rain, a certain concentration of golden algae growth, and it they produce some kind of contaminants which resulted in mass deaths of fish and other animals. And because of that, some NGOs picked up this idea of maybe creating a similar illegal institution as it is based in New Zealand, so Whanganui River, and now they have a legal proposal on the website. They are also being stimulated by some people from academia, by my colleague from University of Białystok. All right, so this is where we are. We have it's I would say a little bit in French, it's à la mode to have legal prescriptions or legal proposals based on the idea of personality of ecosystem, of personality of rivers in different corners of the world. And what we try to understand in our research project, what are the potential risks of implementing rights of nature, and to what extent it's a kind of universal answer, and to what extent it's an effective answer, which can be put into different legal systems, right? Those risks are those which I have already mentioned at the beginning of the class, by saying that it comes with a certain price, and it's a concept which is not necessarily well rooted in some legal system, especially in continental Europe, or in countries which are not necessarily having colonial or post-colonial past. This is a risk number one. Then there's also a problem with clearly identifying and defining those rights. Yes, very often we think about the right to exist, but also the right to restore is mentioned very often. So when you think or reflect about the right to restore the river, it's not necessarily clear to what extent it should be restored. Should we restore the ecosystem to its status or stage how it existed, I don't know, 1,000 years ago, before humans settled down on the banks of the river? To what extent it should be restored? Then we are quite afraid also as lawyers to something that we call strategic litigation. So we may expect mass cases or very expensive cases which do not necessarily have as a goal to protect some elements of nature, but also to weaponize nature's personhood, and to do it in an instrumental way for political or competitive reasons. Also, in order to, for example, block certain economic activities. It's very easy to use such kind of arguments in order to lobby for or against some kind of economic activities or solutions. And also, when we talk about rights of nature, we also see that they are not necessarily automatically equipped to deal with the whole complexity of ecosystems, because between different nature species or elements of the nature, you can see also competitiveness or conflicting interests, right? So all those questions are not necessarily very easily can be solved. Then also in our research system, in our research project, we when we analyze already the results of functioning of rights of nature in Ecuador, we clearly see that it plays a very important symbolic role, but in the vast majority of cases which we identified, usually rights of nature, they appear in combination with some other pre-existing principles of environmental law, which can, to our understanding, play the same function, like the human rights to clean and healthy environment, or the right to restitute, or the right and obligation to to run environmental impact assessment or precautionary principle or principle of prevention, etc., etc. You have a number of tools which already exist in different legal systems. They can be quite effective, and to our understanding, is maybe easier or more intuitive to use the already existing tools as and repair them and make them more optimal to different scenarios than to implement new legal solutions which can be too risky. We also see in our research results that rights of nature rather play something that I would call auxiliary role or subsidiary role. They are being used as a kind of additional argument in order to make environmental argumentation stronger, but they do not necessarily play an independent role. Also, something that we had mentioned about the intrinsic value of nature is something that can be found. And when you take a look at the evolution of environmental law, I don't think it's accurate to say that it's true anthropocentric or it's not taking into account the intrinsic value of nature. And you have a number of examples of international law on the screen, like the Berne Convention on Conservation of European Wildlife and Natural Habitats, which is from 1979, which mentions that recognizing the wild flora and fauna constitute the natural heritage of aesthetic, scientific, cultural, recreational, economic, and intrinsic value that needs to be preserved. Also, in the United Nations World Charter for Nature from 1982, you find a sentence that every form of life is unique, warranting respect regardless of its worth to man. And also in the Convention on Biological Diversity from 1992, the intrinsic value of biological diversity is there. So from the wording, from at least of those three examples of international law, you clearly see that you have a number of provisions which are important and important in an important manner, emphasizing the intrinsic value of nature. So this is what I wanted to say. Let me go back to the previous slide, because I had question to you, or maybe you have questions to me, but I wonder, what is your opinion? Do you think legal personhood is something that is appealing to your imagination? I think it could make the legal systems of countries where you come from better. And you don't have to be a lawyer in order to have some kind of opinion on that question. And do you observe some issues with the current framework of river protection which could be solved through rights of nature? You can provide a tentative answer to this question, but of course you can ask your own question to me, and we have as we have still 10 minutes, we can have a tentative discussion on those issues. I stopped sharing the screen and I leave it to you if you want to ask a question, and we can have a discussion.
Thank you, Piotr. It's very interesting. Is there any questions or response to Piotr's questions online? Shall I start with a question? Unless there's somebody else. Yeah. So I thought it was really interesting why you looked at, when you looked at, is rights of nature just applicable to rivers? I know this was water. I just wondered, is there any examples where it's been applied to other environmental ecosystems, for example, water ones like oceans or lakes, or even the atmosphere or peatland soils or something? I'm just wondering if there's any other environmental examples under this rights of nature law.
Yes, there are some other examples. For example, in New Zealand, there's a Taranaki River. If you go to New Zealand, there's this famous volcano. the Taranaki mountain. But in Ecuador, if you take a look at the constitution, they provide rights of nature to all nature. They say in the preamble of the constitution that Pachamama, so the Mother Earth, is a legal person. So you can also have this this perspective. And also in the same country, there was a case called Estrelita. Estrelita means a little star, and the Estrelita was the name of a monkey who died, who passed away. And there was a case in front of the Ecuadorian Constitutional Court, and this monkey which passed away was provided rights, and these were not animal rights, but rights of nature, in the sense this monkey constituted part of the ecosystem. And for that reason, it was granted rights of nature. So you have the whole variety of different possible answers to that, but it's true that the majority of cases and the most interesting cases are related to rivers for some reasons.
Okay, no, thank you. It's very interesting. We've got a question in the chat there from Kay White. I mean, I can read it out for everyone in case some people are just listening. So Kay says, how does the rights of nature differ in legal terms from things like national parks, protected areas, nature reserves, etc.?
A very good question. A very good question. A very tricky one. This is something that we try to analyze in our research project, and I would say the first and the most important difference is a symbolic. It's a symbolic layer. So if you declare a mountain is a legal person, it means something different than it's just an object of protection, right? Because if it's a legal person, you cannot deprive rights. You cannot change the law to a certain extent, right? If you say it's just a national park, you can declare a national park, but you can cancel. You can change the borders of the park, etc., etc. So the practical and symbolic dimension is very important. But then when you take a look to the extent of protection, then it may happen that national park provide a stricter protection than those ecosystems where rights of nature were declared. And I provide you an example of a Te Urewera forest. It's not a river in this case, it's a forest. Te Urewera is again from New Zealand. And it was a forest which was granted legal personality. And again, it was a part of the decolonialization process in New Zealand. For example, I was pretty much surprised when I visited the site to what extent the legal prescriptions on hunting are legal over there. This is something that will be very difficult to imagine even in Europe. You can even if the Te Urewera forest is a subject of rights, you can buy a helicopter trip for hunting over there. The only difference is that this business is being run by Maori people. So those who know where to land and in what parts of the forest hunting is okay, and which animals you can kill or not. But Maori people, they say we are hunters ourselves, and it's part of the natural process that we as Maori people used to hunt, right? This is part of our relationship, right? We respect nature, but we are also hunters. And it was interesting to see that. So it is something that you wouldn't believe in classical national parks. So this approach to rights of nature can be sometimes, I would say, counterintuitive. But it's a very, very interesting point, and this is something that we will try to take a closer look at this in our research project. What are the practical differences, right? What are the practical consequences of that?
Thank you. It was very well answered. Doug's also put a question in the chat saying, Piotr, several of your examples attempt to establish river rights have run into issues of multiple jurisdictions. Is there any way to navigate competing jurisdictional interests?
Well, this is yeah. So rights of nature could be an answer to a competing jurisdictional interests, because very often the rivers, they cross borders of states, or ecosystems are cross-border. They ignore the borders between states. For example, in Poland, in our research project, one of the cases we analyze is something that is called the Białowieża forest. It's I think it's the very last primary forest we have in Europe. And there's a discussion whether rights of this forest should be declared. The interesting part of the discussion that the forest is between Poland and Belarus. So a conclusion would be that it only makes sense if there's an international cooperation of the two states, which declare parallelly rights of nature of this forest, right? Because only then nature can function independently from the human activity. But it's true. It's this is something that that indeed creates or implies that the need of jurisdictional cooperation of states.
Thank you. I think we have time for one more quick question from Margaret online. She says she's apologizing. She missed the start of the lecture, and you may have mentioned it, but she wonders if you had an opportunity to think about regulatory frameworks such as the EU Water Framework Directive. Do you think that is currently fit for purpose, and what might needed to be upgraded or improved on this instead of developing rights of nature?
The Water Framework Directive was already a very ambitious legal tool, and many countries had some difficulties in implementing, including Poland was one of the very last countries of implementing the Water Framework Directive for economic reasons, mostly because one of the principles is that water management should not create public debt, right? So, for example, the whole water service should be based on some kind of idea that that it self-finances itself, which means also that on the one hand, the water should not be wasted, but on the other hand, it means that water will be more expensive. But European Commission and European Parliament, there are at least two reports which are analyzing the possibility of introducing rights of nature into European legal system. And one is very enthusiastic. It was run by colleagues from University of Siena. It was mostly an Italian team and others. It was quite enthusiastic. Also, our colleagues from University of Bologna were there in the team. I had a discussion with them. And another one was much more reluctant. And it was run by one professor from Sweden and some people from France. And I must admit, this skeptical report is much more convincing to me. I think it is much more realistic. I think that the legal differences and cultural differences between our legal cultures in Europe are very strong. I don't think it would be wise to try to implement rights of nature from the top, so from Brussels, how some people say. If there's a very important risk, it would be rejected by societies. And I think it's much better to take a look at rights of nature not as a goal, but rather as a tool. We first have to identify what do we want to achieve. And usually what we want to achieve is a better balance between, or more optimal balance between environmental protection and economic activity. And where the balance is in different societies, in different communities, in different places, it depends, right? The practical consequence of implementing rights of nature, at least in New Zealand, is that the participatory procedures are much more active, right? So, for example, where the rights of nature were implemented in Wanganui River or in Teureuera, so it means also a much higher inclusiveness of local communities in discussions, in decision-making processes, etc. And I think this is something that has a great value. But you can achieve this value not necessarily by implementing rights of nature. You just have to emphasize on participation, right? But through participation, you can achieve different results or different consequences. Like I said, because of this participation process, Maori tribes decided to allow helicopter hunting in Teureuera forest, right? So it's quite surprising, right? And even shocking for some people, right? But so I would be very careful. I think if rights of nature are implemented, it should be rather a bottom-up process. So it should be an idea of local communities who want rights of nature to be given a given place, then it makes sense. But if it's implemented from the top, it can be dangerous because there's a number of cases where it was rejected or led into some kind of legal mockery, I would even say. It also under-legitimized the already existing environmental actions. So I'm rather careful in suggesting it to European Union institutions because it may lead into throwing the baby out of the bathroom, how we say, or of the bath. I'm not sure how we should I say it.
Thank you, Piotr. I think that's all we have time for today. But I just want to thank you on behalf of everyone again for a fascinating presentation. I feel I know a lot more now about rights of nature and environmental law. So thank you very much for being so detailed. We now have a bit of a break in the seminar series for Christmas holidays, but we will be back in January with some more presentations. I'll update everybody in the meantime, but thank you again.
Thank you so much. Thank you for your attention, and we keep in touch. Bye-bye.